May call your first witness. Direct examination of Stephen Mullin. Now again, the interviews within the hearings I will cut out to separate videos. That way it will be easier to find for everybody involved. Now, this stream is also dated, but it will also be released as separate videos. I know that those videos get very few views because it's not even though I wish they would be, it's not. It's just for the purpose of being easily found. Direct examination of Stephen Mullen. Mr. McClelland, Judge, the state would call investigator Steve Mullins. Oh, another guy that at the same time that Judge Gull enters the depths of hell, so will Mr. Mullin. Question by Mr. McClelland. Will you state your name, please? Stephen L. Mullin. And where are you employed? At the Carroll County Prosecutor's Office as investigator. And how long have you been employed in that capacity? Since January of 2020. Don said, yeah, Hennessy is really good at letting the judge dig her own hole. Yeah. He refuses. Mr. Hennessy is refusing to allow Judge Gull to just skim things over. Because he knows what an absolute shithead she is. And prior to that employment, were you employed in law enforcement capacity? Yes, I was. Can you tell me about that, please? I was a police officer with the Delphi Police Department, and then a deputy sheriff at the Carroll County Sheriff's Department, detective at the Carroll County Sheriff's Department, chief of police in Delphi, and then at the Carroll County Prosecutor's Office as an investigator. So this piece of human garbage, a lies in human form, was directly involved in the interviews, or should I say, in my opinion, the deletion of 70 days of initial interviews. That in itself, folks, the deletion, whether it's intentional or not, I believe it was absolutely intentional, should have made this case go away. Because it made it impossible for the defense to cross-examine certain witnesses, to even call certain witnesses. I believe it was but here's the thing. Since they couldn't prove it was intentional, and the cops involved said, oh, whoopsie. And with Judge Gull, yeah. Jesus Christ, I hate this. How long have you been a law enforcement officer, if you know? 42 years. So for 42 years, he is collecting taxpayers' money, doing shit as an investigator. Okay, as part of your duties with being an investigator in the Carroll County Prosecutor's Office, are you working on the case of the state of Indiana versus Rick Allen? Yes, I am. And tell me largely what your role has been in that case up to date. Hennessy, objection, relevancy, we're here for contempt. This investigation regarding the issues raised by the prosecution's information is what is relevant. The court overruled. Mr. Hennessy, not in investigations of the court overruled. Judge, I'll rephrase the question. I'm okay with staying away from that. Yeah. Question. So I want to move on, Mr. or Investigator Mullins. Are you familiar with an individual with the name of Brandon Woodhouse? Yes, I am. And how are you familiar with him? Brandon Woodhouse has been arrested in Carroll County for various law offenses over the years. And so it's fair to say he has a lengthy history, criminal history in Carroll County. Yes, he does. Now, Mr. Woodhouse came on your radar more recently in March of 2023, is that correct? Yes. How did he come on your radar during that time? I received a phone call from a person who identified herself as Dorina Hipscher. She informed me there was a YouTube channel that Brandon had created. And did you go and view that YouTube channel? I did. And what did you see on the YouTube channel? On the YouTube channel, I observed that Brandon Woodhouse had a screenshot of the listed evidence in the Richard Allen case. And you were familiar with that list of evidence? Yes, I was. Have you viewed the evidence or the discovery involved in the Richard Allen case? Yes, I have. And is it safe to say you're familiar with that evidence? Yes, I am. I'm going to show you what's being marked as States Exhibit B, I believe. Mr. Hennessy, States Exhibit what? Mr. McLean, 2. I'm sorry, Judge. I misspoke. States Exhibit 2. Investigator Mullin, can you describe that document? Yes, it's the same as I saw on Brandon Woodhouse's YouTube page. It's titled Richard Allen Thumb Drive Map. And what was the title of the document that you saw on Brandon Woodhouse's YouTube page? Yes, it was. And tell me, you told me the title. What does the document contain? It contains information concerning the Richard Allen case, witnesses and evidence for the case. And does that match what is on the YouTube channel for Brandon Woodhouse? Yes, it does. Mr. McLean, Judge, the state would move to admit what has been marked as Exhibit 2 into evidence. Mr. Hennessy, no objection. The court, all right, without objection, 2 is admitted. Folks, I need to get myself something to drink because my throat is drying up a bit. I'll be back in a couple of seconds. Thanks for waiting. Oh. Yes, of course I have skull-shaped glasses. If I could have merch in the shape of skull, I would, but I don't have that option. Ah. Okay, I see there's a discussion regarding Andrea. Andrea is still covering this case. I talked to her, and once we get to the actual trial, she will be here as one of the voices to help. At least, yeah, she would help with the reading of the actual trial. Well, when we come to trial, she will be here at some point, at least. That is the latest I've heard from her. And yes, she has offered her help to the appeals attorneys, but it appears that the appeals attorneys doesn't require any assistance, at least. She's still passionate about Rick's case. But since we are all in the waiting game, she covers other cases. I cover other cases as well. Now, I have the time for this because I make the time for this. She has less time. So she does it by finding other cases that she's equally passionate about. So please know, she does what she can. If I have questions for her, she will always answer, and that is good. She's doing good. All right, let's continue. As your role as of the investigator, you've also been tasked by me to assist in the exchange in discovery with the defense for the Richard Allen case. Is that true? Yes. The person who fucked up the 70 days of interviews is the same person tasked to hand over discovery to the defense. Isn't that really fucking strange? How would you make it as easy as possible to hide things from the defense? Well, by tasking the person who has hid things before. I mean, it's so clear. This was why he was tasked with exchanging discovery. Because he knew how to hide it. Yes. And tell me the normal procedure that you go through when you're exchanging discovery with the defense. My practice was to create an itemized list of the items that were to be given over to the defense, whether they be information files or whatever they were, and then have the defense and agent sign for the release of those items. And so you would draft a receipt or a list of items you were handing over to the defense, and then have that for the defense to sign once those items was picked up. Is that correct? Yes. I'm going to show you what's been marked as State Exhibit 3. Can you describe that document that I handed you? Yes. It's a receipt which I drafted for a release of evidence. I titled it 1-0 or 10 Allen. And can you outline the evidence, or is that a document you drafted? Yes, it is. And does it have both Attorney Ross's and Attorney Baldwin's name on it? Yes, it does. And did that document describe evidence that you turned over to them as part of discovery? Yes, it was. And again, that's a document you drafted? Yes, it is. Judge, the state would move to admit what's been marked as State Exhibit 3. Mr. Hennessy, objection. It's never been provided to me in discovery regarding the contempt proceedings. I asked to enlarge the discovery deadline, and the court denied it. And I object because it's never been provided to me before, and it's not been connected to the thumb drive map, and therefore it's not relevant. Court, any response? Yes, Judge. If the court would just give me a moment, I'm going to pull up the date of that email that I sent Mr. Hennessy that had that attachment in it. In terms of relevancy, Judge, I believe it's relevant for information that's going to appear later in the hearing in terms of a continued leak by defense of information. Judge, I apologize. I'm having trouble. I sent all the attachment, all the exhibits in an email. Judge, I'm trying to get the court a date for that email and confirm that Mr. Hennessy received it. Judge, I apologize. I can't seem to find the email at my fingertips here that I sent Mr. Hennessy. But it was included in an email with other attachment that I sent to Mr. Hennessy as part of discovery from the contempt. Mr. Hennessy, can I? The court, no, he's still looking. I guess I'm not sure what the objection is. That you didn't get it? Your client certainly got it if they signed for it. Mr. Hennessy, I didn't get it. What you ordered was to exchange the exhibit for the contempt hearing. The court, yes. Mr. Hennessy, even if they had it, it was never identified to me for potential use in the contempt hearing. That's the kind of notice that the reciprocal discovery requires. And I will also note that the items that are listed in State's Exhibit 3 are not on State's Exhibit 2. And so 2 was admitted without objection because it was the attachment that was accidentally sent to Mr. Woodhouse. So since the item listed on 3 aren't on 2, it's not admitted. It's not relevant. The court, I'll show 3 is not admitted. I'm sorry? I will show 3 is not admitted. Mr. Hennessy, thank you. I'm sorry, but the court, do you need an assisted listening device? Oh, you garbage human being. Mr. Hennessy, I'm sorry. Oh, no, I just tried to. The court, go ahead. Mr. McLellan, thank you, Judge. And so, Mr. Mullin, or Investigator Mullin, yeah, it was never sent. I know. Mr. McLellan is trying to get away with everything. He lies to the court. He gets caught, and then, oh, but that's just a mistake. Aw, just a mistake. And so, Mr. Mullen, or Investigator Mullins, is your practice again to draft a receipt for the defense for when they picked up discovery? Yes. Okay, and you would list out the discovery in that receipt. You would list the discovery that you were turning over to them. Yes, I would. And then you would have somebody, a representative from their office or them themselves, sign for the discovery and date when they receive that discovery. Is that correct? Yes, that is correct. And what was your common practice for all items that you turned over as part of discovery? Correct. Yes, it was. Okay, do you recall, as part of discovery that you handed over to defense, do you recall there being an interview with a professor from Purdue with the name of Jeffrey Turco? Oh, the Purdue professor which the state And the investigator said, we don't remember the name, and we don't think we will ever find out the name. And then the defense says, oh, well, here it is. So all of a sudden, it was really easy, because what the prosecution said to the court, or in a motion at least, is that this professor said, no, there is no connection to Odinism found on the crime scene, which was a lie. This Purdue professor said later in an affidavit that it can be. So they lied to the court, but they are allowed to, because Judge Gall allows them to lie to the court if it suits her. Yes. And what kind of was it an audio video interview, or what kind of interview was that? I believe it was an audio interview of Professor Turco that I handed over to the defense. And would you have gone through the same procedure when you handed over that evidence to the defense of making a receipt and documenting that in the receipt, meaning when I say that, meaning what discovery you're handing over to them? Yes, I would. And would you have had the representative from their office date it when they picked it up? Yes. Do you recall from your memory when the defense picked up the information concerning the interview with Professor Turco? I believe it was September the 27th. I don't have the document in front of me. After. Or in connection. Oh, I mean, the Franks motion was submitted in September of 2023. And by, now we found it. The thing that we said never existed. All of a sudden, they found it in view and handed it over. Because they were caught lying. And what did Judge Gall do about lying from the prosecution? Nothing. Okay, yes. So you believe they picked up that information on September 27th of 2023? Yes, September 27th. Mr. McLeland, I don't have any other questions, Judge. The court, Mr. Hennessy. Thank you, Judge. Cross-examination of Stephen Mullin. Question by Mr. Hennessy. Question, you first learned about the Brandon Woodhouse YouTube from Miss Hipsher. Yes, I was. And what she told you was that Brandon Woodhouse actually had Rick Allen's thumb drive, didn't she? Something to that effect, yes. And was that not true? No. And on the YouTube, you saw the map of the thumb drive, correct. And that simply identified what was on that thumb drive. Can you repeat the question, please? Sure. The map simply identified what was on that particular thumb drive. I'm sorry, I'm not sure I understand what you're trying to say. Yeah, it's the brain worm exists in Delphi as well. I'll move on. Do you organize discovery for the prosecutor? Yes. Do you make a list that's handy for him and his assistants to locate any particular piece of discovery? I create an itemized list of the items that we have as I go along, yes. So that would be like a map for them to go find the actual piece of evidence. I have done something like that, yes. And that is exactly what you saw on the YouTube, only it was for the defense, correct? What I saw on the YouTube channel was what I said earlier, and the picture shows what that was that it was. At the top of the page, it said Richard Allen thumb drive map. But it did not have any substance of what anyone said, correct? It showed a list of the items and witnesses, correct. But it didn't say what the witnesses had said, correct. So there was no substance to it. In that sense, yes. And then did you see anything else on YouTube? Mr. Woodhouse was simply talking about the items on the list of items that were on the thumb drive, or what he called the thumb drive. Did he show any pictures? No. And then, did you ever contact Mr. Woodhouse? I did not. Did you interview anybody else regarding the Woodhouse document? Other than Mrs. Hipsher? No. And you saw the actual email that was accidentally sent to the wrong recipient, Mr. Woodhouse? I don't believe I did. So you don't know it was addressed to Brad. and not Brandon? I don't know. Why did you not look at the actual email? I have enough to look at. I didn't have time to focus on any other issues other than this, and I handed my report over to the prosecutor. So you couldn't read a 4-line email, but you went through a multiple-page thumb drive map. I looked at what was on the YouTube channel and transmitted that to the prosecuting attorney. Right. But you just told me you didn't have time to read a 4-line email that said Brad and not Brandon. You just didn't have time, right? I'm not sure I understand your question. Okay. Well, I'm asking you if you have just said today under oath that you just didn't have time to review the 4-line email that was addressed to Brad and not Brandon. Yes. Okay, so you, as you sit here, have no knowledge whether Mr. Baldwin intended to email Brandon Woodhouse, correct? As I said, I only looked at what I had in front of me. Right. So you have no information or knowledge that Mr. Baldwin intended to email Brandon Woodhouse. I don't know what his intent was. I'm sorry. The question is, do you have any information, Mr. McClelland, which I'm going to object? He's asked and answered the question. He can speculate as to what Mr. Baldwin meant or did not mean to do. Mr. Hennessy, well then, Mr. McClelland's not understanding the question either. I'm not asking him to opine as to what Mr. Baldwin's intent was. I am asking him if he has any information or knowledge. He was assigned to investigate Brandon Woodhouse. The court, but that's not the question you asked him. You asked him what his intent was, and he said that was the objection. I would sustain the objection. Okay. Do you have any information or knowledge? Strike that. You were assigned by Mr. McClelland to investigate the Brandon Woodhouse information, correct? Mr. McClelland, Judge, I'm going to object again. That's not what Mr. Mullen testified to. Mr. Mullen testified he was contacted by Ms. Hipsher that Brandon Woodhouse had a YouTube channel and he viewed that YouTube channel. The court sustained. Question, size. So Jody is perfectly able to add in these kind, but she doesn't do it towards the prosecutor or the judge's eye rolls or the judge's size. After you spoke to Ms. Hipsher, did you report that to Mr. McClelland? I'm sorry, can you repeat the question? Sure. After you got the information from Ms. Hipsher, did you report that to Mr. McClelland? Yes, I did. And what did he tell you to do? Document it. And why did you then go watch the YouTube? I already watched the YouTube when I reported it to Mr. McClelland. Okay. And then do you have any information from anyone that Mr. Baldwin meant to send an email to Brandon Woodhouse? Again, I'm going to object. Mr. Hennessy, it's information, Judge. Does he have any information? The court overruled. Mr. Hennessy, that's a yes or no question. The court overruled. Do you have any information that Mr. Baldwin intended to email Brandon Woodhouse? I don't know what his intent was. Mr. Hennessy, can you direct him to answer the specific question, Judge? The court, did you have any information? Oh, no, I did not. Do you have any knowledge of such? No, thank you. I mean, this is a 10-minute back and forth because I'm reading it quite fast. But he is trying to avoid answering the question asked. And then you did no other investigation regarding Westerman's photos or any other leaks? No. In your employment with the Carroll County Prosecutor's Office, did you become aware of other leaks, other investigation of any other leaks? Mr. McClelland, Judge, I'm going to object to relevance. That's not what we're here to discuss today, Judge. We, the state, has outlined the contemptuous information, and it's the state's belief that the investigation of other leaks and whether or not he's conducted those or looked into those isn't relevant to the information here today, Judge. The desperation here from Mr. McClelland, because I could bet money there are other leaks that Mr. Mullins looked at, but he found that it was from the prosecution, so he did nothing. Mr. Hennessy, I just only asked if he investigated anything else, and his answer, no, would have been a lot shorter than this discourse. The court sustained. Of course she does. And then, you remember giving a deposition on March 1st? Yep. Or 2024? Yes. And you were under oath? Yes. And do you recall saying that Mr. Woodhouse was displaying screenshots in his YouTube video? Yes. So you did see some screenshots in the YouTube video. I saw the display on his laptop showing what I've already described as the information contained in Richard Allen thumb drive map. And then you took screenshots. I did. That's all I have. Wait, Ms. McLean, that's all I've had. Mr. Hennessy, Ms. McLean, Judge, thank you. Redirect examination. So when in the deposition, when he said that Mr. Woodhouse was displaying screenshots, he didn't. Mr. Mullins took screenshots. Questions by Mr. McLeland. Investigator Mullen, the outline that you saw on Woodhouse's YouTube, is that something you created and then handed over to the defense as part of discovery? No. Okay. And so have you ever seen that document prior to viewing it on Mr. Woodhouse's YouTube channel? I had not. And so it's not something that someone else created that you turned over as part of discovery. Is that correct? I did not create that document. Okay. When you saw the YouTube channel, the information in the probable cause, meaning the witnesses' names, was that information sealed, do you know? I believe it was at the time. And so the outline listed several of the witnesses, including some juvenile witnesses. Is that correct? It did. I don't have any other questions, Judge. Mr. Hennessy. Recross examination. Question by Mr. Hennessy. What was the date of the email? I don't know what the date of the email was. I didn't. So I never saw an email. So you don't know if it was before or after anything was sealed or unsealed. That will be correct. Okay, and then, did you know that the affidavit with those names had been leaked by Gary Baudette before they were unsealed and before it was available to the defense? I don't know. Okay, nothing further. All right, thank you, sir. You may step down. Thank you.